Mr. Harris, on behalf of the state.
Your Honor, the defendant, as we discussed in chambers, continues to test positive. It appears she needs a higher level of care. Well, through DeCoach, that she be placed in residential treatment. We also will request $250 in laboratory fees. That would be to the Franklin Police Department. There's also a weapon involved. We would ask that be forfeited and destroyed.
Officer Torek, what's the recommendation of probation?
Your Honor, probation does think that Mrs. Poole is amenable to community control. Her positive drug test at DeCoach earlier this month.
Wait, hold on, Officer Torek. Why do you keep shaking your head, Miss Poole?
Because I'm clean.
No, you are not clean.
Sir, I'm doing the programs. I'm meeting with my counselor. I am. I don't know what's going on. I don't know if it's the medicine I've been taking for my seizures. I don't know what it is, but I swear to you on everything I love, I'm not doing anything. I wouldn't do it again. I don't want to. I've got 2 jobs. I'm keeping busy and keeping occupied with other things. I am. I don't know what happened. I really don't.
I'm sorry, go ahead, Officer Torek.
I was informed that she did have a positive confirmed test at DeCoach on the 10th of this month. She tested positive again today. The recommendation from treatment at the time of her assessment was for outpatient. However, considering the positive test that was confirmed by DeCoach on the 10th and the 21st, which is being today prior to court, there is a recommendation that there should be at least an increased level of care.
Are we sending today's test out?
Yes.
And we don't have the results of the oral swab?
Not yet, Your Honor.
Because Officer Conroy, your position is she's not even close to being clean, right?
That's my position. When I tested her this morning, her sample was bright green, which is a sign to us that she was possibly using something to alter the test or flush her system.
This is where the tension in the courtroom really spikes. Rachel is insisting she's clean, saying she has a kidney infection, takes seizure medication, and only has 1 kidney. All explanations that could potentially affect her physical condition. But from the judge's perspective, the bigger issue isn't just the failed tests. It's credibility. Once a defendant loses credibility in court, every explanation starts sounding like damage control instead of truth. And notice how the probation officer mentions the sample being bright green, which immediately raises suspicion of tampering or flushing the system. That detail alone completely shifts the tone of the hearing. The judge was actually leaning toward residential treatment at first, but now he's openly considering prison. That's a massive swing in just a few minutes. What do you think? Should the court have given her the benefit of the doubt until every lab result came back, or was the judge right to act immediately?
I have a kidney infection. I'm on antibiotics. I only have 1 kidney. I've passed every other drug test. I honestly don't understand what's going on.
Here's where we're at, Mrs. Poole. The recommendation of Officer Torek's pretty good recommendation to send you to residential treatment. That seems like the way to go, but I'm not going to do that. I'm going to send you to prison.
Please don't.
I am, because you will, if you don't acknowledge that you are not clean, then there's nothing I can do. But I am going to wait until we get confirmed positive tests. I want to know for sure, 100%. So I'm going to take Ms. Poole into custody today. We're going to reset this for sentencing in a couple of weeks when we have the results.
Please don't, sir. Please. Please, I swear.
Not doing anything today, Ms. Poole, but we're going to know when we get those oral. We'll get the oral swab back from last week, and we'll get the drug test. We'll send one out from today. Then we'll know if you are clean or if you are
I'm not going anywhere.
not being honest. So, Mr. Madden, we're going to continue this out a couple of weeks and get a sentencing date with Ms. Idle.
I'll do that. Thank you.
All right, that's all.
Now, this is one of the most important transitions in the entire case. The court pauses sentencing to wait for confirmed lab results, which tells you the judge wants absolute certainty before making a final decision. But fast forward to this next hearing, and the atmosphere is completely different. The prosecutor comes in hard, emphasizing not only the repeated positive drug tests, but also a brand new pending criminal case that allegedly developed while she was in jail. That is devastating for the defense. In sentencing hearings, judges look heavily at patterns of behavior, not isolated mistakes. And when new allegations pile up while someone is already under supervision, it signals to the court that prior interventions may not be working. The system gave Rachel time, treatment opportunities, and supervision, but now the prosecution is arguing she's simply not amenable to community control, which is legal language for, "We don't think probation can fix this." That phrase carries serious weight in courtrooms.
Email me as soon as we get results. Present before the court is Ms. Poole, right?
Yes, sir.
Represented by Mr. Madden. We have Mr. Harris from the prosecutor's office, Officers Torek, Conroy from Court Services. We are here today for sentencing. All right, Mr. Harris, on behalf of the state.
Your Honor, as the court's aware, the defendant continued to test positive while on supervision, and that being prior to sentencing. She denied use. That had to be sent off to the lab. Since the last time we were before the court, she has a new case that is pending that was developed while she was in our jail. We do not feel she is amenable to community control at this time, and we would ask you to impose a prison sentence.
Officer Torek, Officer Conroy, anything from Court Services?
Nothing further.
Nothing further, Your Honor.
Mr. Madden?
All right, I went to speak with Rachel yesterday in jail and had a long talk with her about the situation. We talked about honesty and how I guess she hasn't always been honest with me or with you, and she expressed regret for that. She told me she wrote you a letter apologizing for lying to you. That the coach program is something she really liked to do. She says she's finished with this lifestyle. She's 47 years old. She takes care of horses. She's a very genuinely a nice person, but obviously she has a drug issue that how many people involved with drugs don't lie. But she says that she's finished with that.
Listen carefully to the defense attorney here, because this is a classic sentencing strategy. He's not denying the lies. In fact, he openly admits Rachel hasn't been honest. Why? Because once the evidence becomes overwhelming, credibility can sometimes be rebuilt through confession and accountability instead of denial. The defense pivots from "she didn't do it" to "she has a serious addiction problem but wants help." And then comes the emotional reinforcement. Her fiancé stepping in to speak on her behalf. These moments matter more than people realize. Character witnesses are often used to humanize defendants and show the court there's still support waiting for them outside prison walls. But notice something powerful here. Her fiancé also admits she lied directly to him. That honesty may actually help more than blind defense would. It shows the people closest to her aren't pretending everything is fine anymore. The real question becomes, is this finally rock bottom, or just another apology before the cycle repeats?
She's changed her life. I know her fiancé, Tony's here. He'd like to address the court if you'd be willing to listen to him, and I know she'd like to address you too.
Okay, sir, what do you want to tell me?
She's been through some stuff. She's definitely has had an issue with some lies. She's lied straight to me with proof in it. I know that she's had a history. Denial. It's been an ongoing problem. Talking to her these last several times, I believe that, I've heard a difference in her voice. She wants to be done. But not only she wants to be done, I told her she has to be. I will add pressure, and I believe she wants to be better.
All right, thank you, sir. Ms. Poole, you get the last word in this. What do you want to tell me?
I'm so sorry that I lied to everybody. I really am. Before, when I was here, I can honestly tell you that I when I got out of here, I had every intention of using again. And I don't right now. I have no desire, and I have had no desire since I was here the last time. I screwed up in a big way, and I am very sorry. I really, truly am. I like my counselor. I like the groups. I love Conroy. And I know that I'm a little slow to the punch here, but I'm ready to do it right if you'll find it to allow me to do so.
here comes the turning point. The judge says something incredibly important. At some point, I have to vindicate the system. That line tells you this case is no longer just about failed drug tests. It's about repeated dishonesty in front of the court. Judges can be surprisingly patient with addiction struggles, but what they usually will not tolerate is manipulation of the judicial process itself. Rachel finally admits that when she left court the last time, she fully intended to use drugs again. That confession completely destroys the earlier narrative where she insisted the positive tests were unexplained. And in sentencing, honesty that comes too late can sometimes hurt more than help. The court now sees a defendant who repeatedly denied wrongdoing until the evidence closed in around her. This is where viewers really split. Some people see a struggling addict finally telling the truth, while others see someone only confessing because she got caught. Which side are you on?
I will not, Ms. Poole. And here's where I'm at on this, is that at some point, I have to vindicate the system. And I cannot continue to listen to the nonsense that you have spewed at me for all this time. When we were here last, I made a fairly convincing argument about how you didn't know how this got in your system. And Officer Conroy was pretty adamant that you were tampering with the samples or something. I don't even remember what all that was entailed. But you were adamant that you did not use meth. And then you get back to the jail, and then you start calling somebody to get the meth out of the car that's in the parking lot of my courthouse.
I just didn't want anybody to get in trouble for my mistake, sir. I really didn't. And it was Tony that I was talking to. Because I didn't want him to get in trouble, and I knew that it could have been my son that drove my car, and I couldn't let somebody get in trouble for me. And I knew that I was taking a
This phone call revelation is absolutely crushing for the defense. According to the judge, after denying meth use in court, Rachel allegedly called someone from jail to remove meth from a car parked outside the courthouse. Think about how damaging that sounds from the bench's perspective. The judge isn't just hearing about drug use anymore. He's hearing about conduct that directly contradicts her emotional pleas from the previous hearing. And even now, Rachel continues trying to explain her intentions, saying she didn't want someone else getting in trouble. But the judge has clearly reached his limit. You can hear the frustration when he says he keeps getting the same sort of nonsense over and over. In many addiction-related cases, courts want rehabilitation over punishment. But once deception becomes a recurring theme, judges often feel prison is necessary to preserve accountability and public trust in the system. This entire hearing transformed from treatment-focused to consequence-focused in real time.
chance when I made that call, sir. I don't mean to interrupt, but you have to know that I couldn't let it happen.
Are you done, Miss Poole?
I'm sorry.
Because it's the same sort of nonsense that I keep getting from you over and over and over again. And while I do agree that you probably do want to do better and that you have an honest desire to do that, you have to answer for the things that you have done in this case. And I think that it would seriously demean the seriousness of this offense and is not consistent with the purposes and principles of sentencing to continue you on probation. So I'm going to order you serve 24 months in prison. I am going to give you credit for the 57 days that you have already done. This includes an optional period of post-release control. That means the adult parole authority can, but is not required to supervise you for up to 2 years after your release. At some point in this pool, you're going to get out of prison, and hopefully you're going to go into treatment when you get out of prison. And you need to realize that there is another path. There is a path of, I'm going to be honest, I'm going to turn from the things that I have been doing, and I hope that you explore that path. Good luck to you, Ms. Poole.
Thank you.
Do we think the prison is here yet, or we don't know?